a probate is going to take 1 year to do. What does that mean? It takes 1 year to do. From the day that we submit the court documents to court, it's going to take about a whole year to complete the process. Do you see this little guy right here holding a bag of money? Only at the end of probate does the son or daughter gets their money. Only when the probate is completed does the son or daughter gets their money, okay? So that's a very important concept to remember. When can you close escrow? Do you have to wait until the year is over, guys? You can sell the house during the probate process. So the question is when, right? When can you sell that house within that 1 year? What are the legal documentation that escrow need to send to title to close escrow, okay? So we file the paperwork with the court. The moment we file the paperwork with the court is going to charge your client a filing fee of $465, $465, okay, to initiate the probate process. So if you look at your screen, you see file petition for probate, bam, the court collects $465. Not me, but the court does, okay? The court is going to say, hey, will you please find a local newspaper in that city and publish in a newspaper? You have to do that. You have to basically say, hey, case number so-and-so, here's the hearing date. That's called newspaper publication. So normally 30 days later is the hearing. Sometime with COVID-19, it might be 2 months, 3 months later, okay, with COVID-19 special, okay, a bit of a delay, okay? So we file the probate petition. We publish in a newspaper. Normally, without COVID-19, it'll probably, come back to a normal time, which is about 5 or 6 weeks. So let's say about 6 weeks later is the court hearing date. At that court hearing date, 6 weeks after I file the petition, 6 weeks later is when the judge is going to say yay or nay to appointing the petitioner as the personal representative. Start the petition, pay the court filing fee, get a court hearing date. On that court hearing date is when the judge is going to appoint that son or daughter. Normally in a normal scenario, 2 months later, you should get letters and orders. Letters and orders are legal documentation. Letters and orders are legal documentation from the court. The order looks like this. It's signed off by the judge. For example, if you see right here, signed up by the judge saying, hey, this particular individual, in this case, for example, Deborah, this particular individual is appointed as the administrator, okay? Once the son or daughter gets appointed, it's signified by the word order, by a legal document order signed off by the judge, and also at the same time, letters are issued too, okay? So two important pieces of document, orders and letters. Orders and letters are two documents that signifies that your client, your son or daughter, is now the legit personal representative that can move on to close escrow for you. Let's say, for example, if you're working in this lead, January 27 comes along, the son and daughter gets approved, 2 weeks later, letters and order comes out. You would give the probate attorney the probate purchase agreement. He'll go ahead and draft the notice of proposed action. It looks like this. It looks like this, the notice of proposed action, okay? So if a particular probate is full authority, then you're only gonna need 3 documents to close escrow, okay?